Hello and welcome back to Tenant Law Basics. This is a series of short videos looking at landlord and tenant law in England and Wales in the United Kingdom. I'm Tessa Shepperson and today I'm going to be looking at the difference between a tenancy and a licence. Now, in the earlier parts of this series I've been talking about tenancies and how you create a tenancy, and I did say in one of the earlier videos that you need to know whether you've got a tenancy because it affects the rights that you have. Now, when you go in and start living in a property, when you're occupying a property, there are two legal bases upon which you can do this. One of them is a tenancy, which we've discussed, and the other is a residential licence. Now, what is a residential licence? A residential licence is when you have permission to live somewhere, so you're not a trespasser. So it's, although it may look the same to a non-lawyer, a tenancy is a legal interest in land. A licence is when you've got permission to be there, so you're not a trespasser. So legally, they are very different, and you get a lot of rights that come along with tenancies that you don't get with licences. So when do you create a tenancy and when do you create a licence? Because most landlords would probably rather have a licence agreement with the occupiers of their properties rather than a tenancy. But the law was decided in 1985 in a very famous case, one of the most important landlord cases that we have, which is called Street and Mountford. And this was in 1985. At that time, the governing legislation for tenancies was the Rent Act 1977. Under the Rent Act, tenants had very strong security of tenure. It was very difficult for landlords to evict them if they wanted to get the property back, unless they weren't paying the rent. Now, in this particular case, the landlord was Mr. Street and the occupier was Mrs. Mountford. And she rented a room in Mr. Street's house. And Mr. Street wanted to create a licence, and he created a licence agreement for Mrs. Mountford to sign, and the licence agreement said at the end, "I understand and accept that a licence in the above form does not and is not intended to give me a tenancy protected under the Rent Acts." So she signed that and agreed, and she went in and started living there. And then quite some time later, Mr. Street decided he wanted the property back, so he brought proceedings for possession on the basis that it was a licence. And Mrs. Mountford defended, and she defended on the basis that she had a tenancy. And the case went all the way up to the House of Lords. And in the House of Lords, the main judgment was given by a judge, Lord Templeman. And what Lord Templeman said, basically, was that what you look at to decide whether you have a licence or tenancy is not the piece of paper that people sign, but what actually happens on the ground, whether the occupation has the characteristics of a tenancy or not. So this is a quotation from the judgment. He said, "If the agreement satisfied all the requirements of a tenancy, then the agreement produced a tenancy, and the parties cannot alter the effect of the agreement by insisting that they only created a licence." And then he goes on to say, and this is much quoted, "The manufacture of a 5-pronged implement for manual digging results in a fork, even if the manufacturer, unfamiliar with the English language, insists that he intended to make and has made a spade." So, when you're looking to see, say you're a judge or a lawyer considering a case, when you're looking to see whether someone's got a tenancy or a licence, what sort of things do you look at? What are the characteristics of a tenancy? Well, basically there's 3. The first one is rent, so you have to be paying rent. The second is that there needs to be some sort of term, some sort of period for the tenancy. This can be sort of like a fixed term of 6 months or a year, or it can be a sort of recurring, a periodic tenancy, so from month by month, but there needs to be some sort of term. Perhaps the most important thing is there needs to be exclusive occupation, and the occupier has the right to keep everybody out, and indeed, in fact, everybody is kept out. So even if the agreement says that the landlord's got the right to go in every day, if the landlord doesn't, if the landlord hasn't in fact been in the property for a very long time, then it is almost certainly going to be a tenancy, and if it goes before the court, that is what the judge will decide. So, to summarise, in most cases where someone lives in a property, whether it's a flat or a house or a room, and pay rent, they will have a tenancy. The fact that they've signed a piece of paper which describes their occupation as a licence is largely irrelevant. There are some exceptions to this, and I'm going to be looking at this in the next video. So, thank you for watching.